Committee Room 30, signed. 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 Committee Room 30, Committee Room 30. Sound. 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 Committee Room 30. Sound.
Thank you. Good morning again, colleagues, and I wish to advise members that the committee meeting is in public session, will be recorded and broadcast throughout Parliament buildings. At this stage, we'll take apologies, which we received a few. David Honeyford, Podrick Delargy, Sinead McLaughlin and Kate Nicholl. Any member have any declarations of interest they wish to make at this stage? If none, chairperson's business, just in relation to the interconnector. So, following on from an Assembly written question, Ofgem has released an earlier decision and approved electricity interconnector between Scotland and Northern Ireland. The Utility Regulator is now considering the licence application, with a decision expected by the end of this year. The project obviously will have a significant implication for security of supply. Are members content that we write to the Utility Regulator seeking clarity to the criteria for its consideration in this regard? Members are content. Move then to draft minutes, which are at page 7 of our packs, and cover our deliberations on the 20th of November. Are members content that I sign those? It's a true and accurate reflection of our discussions last week. Members are agreed. Matters arising then, members. The briefing at last week's meeting with Work Plus on apprenticeships, even though issues relating to skills are presently being considered by the Public Accounts Committee, is the committee content to write to the department seeking its commentary on Work Plus's suggestion in respect of a standardised apprenticeship application process, a UCAS-style employer/apprenticeship matching evidence, and an enhanced role for the new the local economic partnerships in supporting apprenticeship development, and whether targets in this regard are to be set. Are members content?
Yes.
Thank you. We then move to item 6, members, which is delegated legislation SR 197 Tribunals. Wish to advise members that the committee will now receive oral evidence from the department on the relevant aspects of the statutory rule entitled SR 197 2024, the Industrial Tribunals and Fair Employment Tribunal Constitution and Rules of Procedure Amendment Regulations, Northern Ireland 2024. I refer members to page 18 of their pack, which is the clerk's covering note, and also to page 19 to 26. The SL1 and SL5 are included. Colleagues, you're very, very welcome along here this morning. We have Gareth Dillon, Head of Employment Policy and Legislation, and we also have Don Henderson, DP in Employment Policy and Legislation. Is that all?
Yes.
Yep, okay, no problem. At this stage then, hand over to you, colleagues.
Very much. Good morning, everyone, and thank you for the invitation to brief the committee today regarding a number of technical changes to the Industrial Tribunals and Fair Employment Tribunals regulations. I'm head of the Employment Relations Work-Life Balance branch, and my colleague is Don Henderson. A number of proposed amendments to the 2020 rules were identified to ensure the tribunals continue to run effectively. These were a mixture of changes intending to align with amendments to the GB rules made following our rules coming into operation, and amendments identified as a result of recent judgments or in consultation with key stakeholders. A short targeted stakeholder consultation exercise on the proposed amendments opened on the 4th of June and concluded on the 20th of June this year. Questionnaires were sent to a number of key stakeholders seeking views on the proposed changes, and a total of 9 responses were received. In summary, the questionnaire focused on 10 high-level issues, and these included setting out the requirements for the presentation of a claim to the tribunal, allowing 2 or more claimants to complete a single claim form or response form, allowing employment judges to exercise discretion in circumstances where there is a minor discrepancy in the early conciliation number provided on the claim form, allowing an employment judge to accept a claim if there is an error and it would not be in the interest of justice to reject the claim, providing for the entry of default judgments, providing for reasonable notice of the date of hearing and the early listing of cases with the consent of the parties to proceedings, allowing an employment judge to sit alone in certain circumstances, and providing for judgments for withdrawn claims to be exempted from the requirement to be recorded on the register. These amendments are made under powers conferred by the Industrial Tribunals Northern Ireland Order 1996 and the For Employment and Treatment Northern Ireland Order 1998, and are subject to the negative resolution procedure for the Assembly. It's proposed that the rules will come into operation on the 12th of December of this year. I'm happy to provide a more detailed overview of each amendment, or if there's anything the committee wishes us to specifically focus on, I can go into more detail.
Yeah, if you could you maybe just run through each of the amendments? Any more detail you have on them would be useful.
Happy to do so. So the first amendment is in relation to the presentation of a claim form in accordance with a Regulation 14 practice direction. This amendment allows the President of the Tribunals to make a practice direction relating to the lodgement of claims. If a practice direction is made, it is published on the website and circulated among members of the Tribunal or users group as required by the rules, and brought to the attention of persons to whom it is addressed. And this ensures that an individual is made aware of any practice direction that has been made, and any practice direction will be published on the Outfed website. The amended rule will bring the position here into line with that of Britain. The second amendment is in relation to Rule 10, and that permits 2 or more claimants to use the same claim form. The regulations amend the Industrial Tribunal's rules to provide for 2 or more claimants to make their claim on the same form if their claims give rise to related issues of fact or law, or if it is otherwise reasonable to do so. It also amends the rules to allow a response form to be included of more than one respondent, or the response to more than one claim if the responses or claims give rise to common or related issues of fact or law, or if it's otherwise reasonable to do so.
Was that if the employees have a similar case they wish to bring against their
if they're related in any ways, it allows for a range of circumstances to be included rather than having separate claims.
Yes. Okay.
So the third amendment is in relation to Rule 11, and that's for discrepancies with the early conciliation number on a claim form. This rule change allows tribunals more discretion over handling of administrative type errors relating to discrepancies between the early conciliation numbers on the claim form and those on the early conciliation certificate, where it is in the interest of justice to do so. The aim of this change is to allow industrial tribunals to handle errors more efficiently and reduce the administrative burden on claimants and rectification of minor discrepancies and errors. The fourth claim is also in relation to rectification of claim forms, and that's in relation to Rules 12.4 and 12.5. This amendment allows employment judges to exercise discretion in circumstances where there's a minor discrepancy in the early conciliation number, and allow for an employment judge to accept the claim if there's an error and it would not be in the interest of justice to reject the claim. The next amendment then is in relation to Rules 19, 23 and 24, and that's default judgments. So a default judgment is a judgment that can be issued at any stage of proceedings where there's a relevant time limit for presenting a response has passed, or if the response has been rejected or struck out. The original policy intention when making the 2020 rules was to retain the provision for the entry of default judgments as was available in the previous iteration of the rules. This was removed erroneously in the 2020 rules, and at present there's no provision for the entry of a default judgment. The current amendment allows for a default judgment to be recorded, as the amendment to Rule 19 allows for, in effect, a default judgment to be entered if the employment judge decides on the available material that it is appropriate to do so, and that a determination can be made. If a determination cannot be made, then the matter will be fixed for a final hearing. The next amendment then is in relation to reasonable notice under Rule 48.1. The intent behind this amendment is so that a tribunal can, of its own motion, fix a preliminary hearing on reasonable notice at any time, as opposed to being limited to only following the case management hearing. The amendment does not remove the requirement for a case management preliminary hearing before any preliminary hearing is heard. Next we have Rule 52, and that is the listing of final hearings with less than 14 days notice. The regulations will make changes to provide that reasonable notice be given to parties of the date of final hearing, and any final hearing may be listed with less than 14 days notice if the parties consent to that. Rule 8 then is in relation, or the 8th amendment, is in relation to Rule 53, and that's for employment judges sitting alone. The amendment to Rule 53 is to allow the employment judge to sit alone in certain prescribed circumstances. Rule 53.1, as it is presently drafted, may not be consistent with Article 6 of the Industrial Tribunals Northern Ireland Order 1996. Currently, there are no final hearings conducted by an employment judge sitting alone, and the need to have a panel or two or more persons, including the employment judge, is costly and could result in delays in proceedings being listed. The intention of the 1996 order was to allow an employment judge to sit alone in certain circumstances, and they're set out in Article 6 of the order. In summary, Article 6 allows for the default position as the proceedings will be heard by the chairman and one or two lay members. Proceedings listed in paragraph 3 of Article 6 shall be heard usually only by the chairman in very routine cases, and a list of proceedings to which paragraph 2 applies, such as interim relief, unauthorised deductions and protections of wages. The relevant rule of 26.2 of the previous regulations prior to the commencement of the 2020 regulations was any hearing of a claim under this rule shall be heard by a tribunal composed in accordance with Article 6.1, 2 and 3 of the Industrial Tribunals Order, and this amendment therefore seeks to restore that position. The next amendment then is under Rule 61 on the recording of withdrawn claims on the register. So the 2020 rules place a requirement on the Secretary to maintain a register which is accessible to the public and free of charge. The amendment provides that judges for withdrawn claims are exempt from the requirement to record on the register. Example, when a claim has been lodged but before it gets to final hearing, it is withdrawn as a result of conciliation via the LRA and has been settled between the parties. It's also intended to address concerns previously expressed by parties about withdrawn claims being visible online, as it can be detrimental to litigants and may have unintended consequences for those involved. The Public Register would now contain only substantive judgments and written reasons for the decisions made by the Tribunal. The amendment will also significantly reduce the working costs involved in maintaining the register, and it brings Northern Ireland in line with current practice in Britain.
Yep. Okay. So most of these then just bring us in line with the rest of the UK and
or restoring the position that was there before.
Okay. Which had changed as a result of the 2020, and they were just oversight changes, were they?
Yes, I think so.
Okay. You weren't involved in those? No problem. Does any member have any other question on this? No, that was useful just to get that because I know a few members had some questions on that, but going into those they had changed it. So if no member has any question on that? No, that's perfect. Thank you very much. I appreciate that. Okay, colleagues, I think there's then a degree of unanimity on this. Does anyone have any questions or issues they wish to consider? Okay. If not, then are members content that I put the question that the Committee for the Economy has considered SR 2024-197, the Industrial Tribunals and Fair Employment Tribunal Constitution and Rules of Procedure Amendment Regulations Northern Ireland 2024, and subject to the report of the Examiner of Statutory Rule has no objection to the rule. Are members content?
Yep.
Agreed. Colleagues, we then move on to item 7, which is the Utility Regulator Bill Departmental Update. The committee will now receive oral and written evidence from the Department on the consultation on the Utility Regulator Support for Decarbonisation Preparation Bill. This session with members' agreement will be recorded by Hansard. Refer members to tabled items, including a revised clerk's cover note and departmental briefing, and refer members to page 37, where there's a copy of the consultation papers, correspondence from the Utility Regulator in respect of the bill at page 51, and related departmental and other papers from page 55. Colleagues, you are both very welcome here. We have Miss Anne-Marie McCann, Director of Energy. Pardon? Oh, sorry, my notes are wrong, apologies. And Paul Skillen, who's the Head of Energy Legislation at DFE. Colleagues, you're very welcome, and we'll hand over to you.
Good morning. Thank you for the opportunity to brief the committee on the proposed Utility Regulator Support for Decarbonisation Bill and get your advice and your views. We're pleased to be here to tell you about the work that we're doing in the department to put in place this part of the legislative framework to deliver the energy strategy in the context of the Climate Change Act. We're delivering the strategy through co-design of a wide range of policies that will help deliver the Minister's economic vision and the wider executive priorities programme for government. So I'll give you a brief overview of the background to the bill, and then I look forward to hearing your views and taking your questions. So on the 16th of December 2021, the Department for the Economy published the Executive's energy strategy, The Path to Net Zero Energy, and that document set out the long-term vision of net zero carbon and affordable energy for all. And delivering the strategy aims to end the price volatility associated with imported fossil fuels and protect the most vulnerable in our society, meaning that the money we spend in our, on energy stays in the local economy, creates jobs and wealth. So the introduction of the Climate Change Act in 2022 provided an additional statutory framework for our work, and its objective of a just transition to decarbonisation fully aligns with the energy strategy's objective of a just energy transition to net zero. So the department's working at pace to put in place the energy policies, enabling legislation and required economic regulation that will provide the direction and certainty for business investment and deliver net zero energy. So the Utility Regulator is an independent non-ministerial government body. It's governed by a board of directors and accountable to the Northern Ireland Assembly. It's responsible for the economic regulation of the electricity and natural gas industries, and in doing so, promoting the short and long-term interests of electricity and natural gas consumers in respect of price and quality of service. As the economic regulator, it has an important role in providing evidence and advice to the department in relation to energy policy development. So there's been significant engagement between the department, the utility regulator and the DSO to analyse the current legislative framework, which provides UR's roles and statutory duties. And the conclusion of that analysis was that to enable the UR to contribute evidence and advice on regulatory issues now to the department's policy development in other energy areas in the energy strategy, we need interim legislation. So a draft bill was produced by the Office of Legislative Counsel and it's designed to ensure that the UR can do this. So on the 23rd of May, the Executive agreed that the draft bill should be subject to public consultation. We've received 50 responses to that, and you received a written summary of the main issues identified. So overall, 76% of respondents expressed support for this bill, although the consultation raised a wide range of issues and there were conflicting views expressed, as well as some confusion as to what the bill was intended to achieve. So some common themes that emerged were, firstly, that the utility regulator is one of several parts of the energy system and a holistic view needs to be taken. Specific reference by consultees was made to the importance of the statutory role of other bodies in relation to consumer protection. Some consultees were of the opinion that there's no need for this bill because the Energy Order 2003, Articles 12.5c and 12.7 provide the UR with fully adequate cover to provide advice to the department on fulfilling our obligations under the Climate Change Act in relation to energy. Then again, contrary to this view, it was suggested the UR should be given wider powers, for example in relation to home heating oil. There were comments that an independent regulator is important and that there's a potential conflict of interest if the UR becomes involved in policy making. And finally, in relation to the financial costs of the bill, the views expressed included that strong justification is needed should the bill result in increased energy tariffs, that the costs resulting from the bill should not be paid by licence fee holders, rather from the Executive's budget. Others said costs should be paid by licence fee holders. There was a view that an increase in advice, information and assistance requests from the department should not be considered to automatically result in additional staffing for the utility regulator. So these were all the range of views expressed. In the future, we are planning to take forward significant legislation that will require the utility regulator to regulate policies aimed at net zero, and all while protecting domestic and non-domestic energy consumers' interests. So the department is focused on urgently bringing forward a legislative timetable for the remainder of this mandate. The purpose of this bill is to allow the utility regulator to engage with the department and provide them with legal clarity that the duties in relation to the Climate Change Act also are covered by the long-term interests of consumers, and that they have that clarity in working with the department. In parallel with that, we are taking forward the mid-term review of the energy strategy, which will be reported to the Executive next year, and there may well be additional legislative requirements as a result of that review. So we welcome this opportunity to engage with the committee and to hear your views on the responses received to the consultation, and that will help inform our position on this draft bill, and we're happy to answer any questions that you might have.
Thank you very much for that. So following the consultation, has the department or the Minister indicated any changes to the draft bill at this stage?
At this stage, we're looking at the range of opinions. There may be some things that we want to have further discussions with the utility regulator and with other bodies that are involved in these areas. Some of these areas we aim to address through the department's response, because they are areas that we can provide clarification on. At this stage, we have we have no indication that there will be any changes needed. If they are, they will be they'll be taken forward with OLC, and obviously that will come back for scrutiny.
You've described this as a interim bill, that it's not the whole piece, but it's something to get over the current gap in legislation. What's the current time frame then that the department have set for this, if it's only an interim bill?
That's Paul to answer that.
Yeah, so as Anne-Marie's saying, there's a process where we'll consider the responses and whether there's any tweaks required to the bill in relation to that. That will then need to be agreed with the Minister, and then that would then go through the Executive. Now, we don't see that as a significant exercise. So the intention would be that would probably start towards early 2025, with the intention with the bill to go through the Assembly then, hopefully before summer recess, but that's obviously outside our control.
Yeah. And one of the representations that we as a committee has received is, yes, it's important that the ER is able to give advice to the department, but it should have a wider remit, that it should be able to give advice to all government departments, given the important role that all departments have, and obviously trying to meet the legislative requirements that were imposed by the last Assembly. So I'm just wondering how you answer that charge, or question rather, that confining the advice of the ER simply to the Department for the Economy limits the collective ability of the Assembly and of the Executive to try and work together to meet their targets.
The Utility Regulator provides advice on energy policy, and the Department for the Economy and the Economy Minister lead on energy policy. We have a wide range of cross-departmental working groups, so where there are issues, for example, the fuel poverty strategy, where there are issues which span departments, we are working closely with the officials in each department on those issues, and therefore we will make sure that if there is advice required on energy or evidence required on energy, that the UR are at the table and can provide that advice.
And what was the feedback then from any other government departments to this proposal? Was there any government department's view that they should also have access to this information or advice from the ER?
Other government departments are very keen to have access to this advice, and we've reassured them that they absolutely will, because if these regard energy areas, those are issues that we will be involved in, and we will make sure that advice is available. We'll be part of that conversation. So we've had those conversations, and we will ensure that is made available. Now, obviously, as more detailed legislation comes forward, there will be much more specific regulatory arrangements brought forward, and those will take into account a lot of the issues raised in consultation, because the consultation, I think some people think potentially that there are more powers being given to the Utility Regulator than there are at this point. And that will be the case potentially down the line, but then all of those questions will be answered. There'll be evidence gathered, they'll be consulted on, scrutinised, and we'll be able to answer all those questions.
Was there any direct ask from any other government department that they should be included as being able to receive advice directly from the UR in this consultation?
Yes, several departments have contacted us. The Department for Communities. Yeah. As I say, they have the fuel poverty strategy is a clear one for them, and also issues such as energy efficiency, etc. I think the DERA are keen, but we've had discussions with them, etc., and explained that we're going to be working at working level, and that being involved in those conversations, that our aim is to ensure that information is available to everybody. The purpose of this bill, we've worked very closely with the Utility Regulator in developing this. We've worked with them in a working group to develop this, and we've agreed this legislation going forward, and we very much value the input that the Utility Regulator can provide on energy issues, and this bill is aimed at actually enable us to get that information. So the whole purpose of it has been agreed with the UR. We're working very closely with them. We value their advice, as do the other departments, and the intention is that advice will be available to people.
Gary?
Thanks, Chair, and thank you both for your presentation. In all of these matters, when we discuss the transition to net zero and dealing with these matters, First and foremost, certainly in my mind, is always the consumer and what it will mean in terms of energy prices, energy bills, what people will be paying. Clearly, in terms of the consultation, one of the common themes around that is actually in terms of what it will mean in terms of licence holders, but ultimately the cost to consumers. I think that's a genuine concern. I want to see, as they say, a fair and just transition in terms of these issues, but it shouldn't be in terms of a penalty to consumers. So could you maybe just talk us through, obviously we have a summary of the issues, but in terms of that strength of feeling about the impact on the consumers, could you talk us maybe through some of the responses that you received?
Okay, well, before I ask Paul to get some more detail on that, I would just like to say that the department absolutely concurs with that view. Our energy strategy specifies that we're putting the consumer at the heart of the energy strategy, and the cost to the consumer is one of the major issues that we look at. So there's the cost protection and also the non-financial protections, and we are aiming to ensure those are built into all of the policies. This is one of the reasons as well why, in terms of energy advice coming from anywhere, that's going to have to be paid for by the consumer eventually. We are keen to make sure that we keep some kind of a feel for that advice and how much of that's happening, because inevitably that adds to the cost for consumers, and we don't want duplication of requests or anything like that. So that's one of the key aims of actually working with the Utility Regulator and indeed with Consumer Council and with other consumer protection bodies as well. So I'll ask Paul to give you some more detail on the specific responses.
Yeah, so as Anne-Marie said, we were very clear about the potential impact in this area, and actually question 3 was actually sort of specifically targeting that. So we asked for the views of kind of electricity and gas holders, and obviously because we were talking about costs, we assumed that other organisations in that area would sort of come forward in that. So 62% of people who responded to the consultation actually provided us information in relation to question 3. 31 respondents, of the 31 respondents that provided views, 24 of them were sort of larger kind of organisations, so companies, public sector, umbrella organisations. And the main themes that came out were about strong justification needed should the bill result in increased energy tariffs. There was obviously a range of different views. Sort of costs resulting from the bill should not be paid by licence fee holders. Rather, this relates to a broader climate agenda, and it's something that government should consider. Other respondents felt that it was that taxpayers' funds shouldn't be using it. But I suppose there was a view that if this did come from licence fee holders, we had to remember that the requests associated that would also potentially have operational constraints on them. So if there's a need for additional resources for the Utility Regulator to provide this, to furnish those requests, the licence holders may need to put in place additional resources. So it's difficult to buffer that from the consumer. There was a view expressed that additional advice and information requests shouldn't automatically be considered to lead to additional staffing. So if you think one of the things Anne-Marie talked in and around was Article 12.5c of the Energy Order, and how the Utility Regulator already sort of provides support to the department in this area. So that was one of the views expressed. And then one of the other sort of themes that came out was it's important that net zero is a large strategic thing, and you need to consider the long-term direction and what this means for the economy and what this means for the environment. So there was a view about kind of long-term versus immediate costs that needs to be considered in and around this. I suppose that's.
Thanks for that. I do take heart. Obviously, the department are mindful that obviously the consumers are key in all of this. One of the other issues that was raised was around this holistic view. So obviously this bill is quite limited in scope in terms of, obviously it doesn't take account for the home heating oil issue in terms of the utility regulators' remit. You've also highlighted in terms of the mid-term review of the energy strategy and potential other issues or potential other legislation required. Is there any early view, and I obviously haven't done the review, so my point being is there any early view from those within the sector who see gaps? Obviously the home heating oil issue is one of them, but are there any other emerging gaps at this stage where you can see potential legislation coming down the road?
Specifically in terms of the home heating oil issue, the department has looked at this, and I think one of the things that has to be understood is that the majority of the cost of home heating oil is the global price of the oil, and therefore if regulation was added to that, it's more likely to actually add cost in terms of having to fund the cost of the legislation than to reduce the cost. And in terms of consumer protections, there are bodies, the Competition and Markets Authority has the jurisdiction to investigate and take action against anti-competitive practice, and there are bodies who have the powers to do that. So because the move of the strategy is away from fossil fuels, our approach would tend to be to encourage the augmentation and the implementation of existing protections rather than adding a whole new layer of protection in that area. In terms of the other gaps, as you say, we haven't started the review, we've started the preparation for the review, and one of the things we have is we have a range of reports from other organisations about where they see the gaps, where they see the particular interests of potentially maybe the members of their group or their particular approach. And we are going to start with a review of all of those and ensure that we are taking account of all of those. We'll engage with all of those stakeholders. We are engaging with them at the moment, obviously, but we'll specifically engage on all of those issues and pull those together and ensure that we actually address issues that seem to be potential barriers for industry, for example, in moving forward. I mean, this review is not intended, it's not going to be a new strategy. The strategy is approved to 2030, but we are at a stage now, 5 years on, where we know so much more about what the evidence is saying, what other people are doing, what we're trying to achieve, and what we want to do here is we want to put in place more clarity of the direction and maybe more milestones so that people can plan their investments and plan their direction of travel. So it's kind of filling in the gaps is the intention of this review, and that's precisely what we'll be setting out to do, to actually say, you know, where things have come up with now more information on them. That's what we want to actually provide more information on the way forward.
Yeah, thanks. So just a final point. I do take your point in terms of obviously the mid-term review, the importance of addressing the gaps, but also the importance as a committee, obviously, of getting the earliest opportunities. A limited mandate left in terms of a limited time in terms of this mandate. And certainly from the sector, what I tend to hear is that there's, whilst there was momentum at the beginning, there's almost a loss of momentum at times, certainly in terms of some of the frustrations around getting approvals, etc., for various renewables. Just a final point was around the utility regulator. You said that obviously a lot of engagement, strong engagement. In terms of the query maybe around, you know, the likes of the independence of the utility regulator, has the utility regulator effectively give his satisfaction or okay to this bill? And, you know, are there any concerns in relation to that independence piece?
No, we don't. That's where I mentioned there was some confusion, and we will address that in the departmental response to the consultation. The independence of the regulator is something that we absolutely will, do not intend to encroach upon, and the utility regulator would not agree to have it encroached upon. We rely on that independent and objective provision of advice and evidence that we can trust, that doesn't have is not affected by any vested interests, and that's what we need going forward to make evidence-based policy. So this does not change the relationship between the department and the regulator in any way. What it does is it provides clarity to them, legal clarity, that their role in protecting the short and long-term interests of consumers covers the work that needs to be done in terms of the climate change work. So it's to give them that role, that clarity, and to allow them to have those initial conversations with us about other energy. It is in no way intended to have them move into policy making or decision making, which is completely the role of the department and the department's minister and the scrutiny of the assembly and yourselves, etc. So that's why we formed this working group, to ensure that we were both happy with it. So we've got complete agreement. And we're actually looking to repurpose that working group into a regular working group, and we're looking at future regulation through that lens to make sure that everyone is content with the roles that are assigned to them in legislation.
No, thank you for that clarity. Thanks, Chair. Thank you.
I wanted to pick up on a point that Gary had raised, and colleagues around the table represent much more rural constituencies than I, and understand the department doesn't want to be seen to be, promoting fossil fuels in relation to home heating oil, but it's the only option for the vast majority of people who live outside of the greater Belfast area. And we're now 5 years into the energy strategy, and there's been no move by the department to facilitate or encourage people whose only current access is to oil to move to a different form of heating. So it's all well and good the department saying we're trying to move away from fossil fuels, but if there's no support or other options available to the consumer, then this is the only show in town. So the department, if they're wanting to tell people to move away from fossil fuels, you're going to need to get on quite quickly and put a support mechanism in place for people to transfer to other forms of heating. Philip.
Thanks. Just the point in relation to your conversation with Gary, it's obviously very important that the independence of the utility regulator be maintained and strengthened, and also that their role is vital when it comes to protecting consumers. So I think we're all going to agree on that. In terms of this, there was views within the consultation that the bill should go a bit further. There's obviously views from other departments that the bill should go further. So I'm kind of trying to work my way through. Is it the department's assessment that they would like the bill to go further, they just don't have time for in the current mandate, or is it that you don't think that there's a need for the bill to go further?
I think there are two separate issues. This bill is intended to give the utility regulator the legal cover to be able to engage with us and spend time and resources on actually providing us with evidence and analysis and advice that we need to develop these new renewable technologies, etc. The other issue of giving them more specific powers is being taken forward in individual policy development, and we do have there are a range of consultations out there, a range of work being done to actually work up schemes, etc., to do that, and those particular pieces of legislation that result from that, those will be much more specific in terms of those areas. I think I wouldn't like anyone to think that this bill was the entirety of the the request of from the utility regulator, because it's not. There is a range of stuff coming forward. This has a very specific remit, and it's to allow the utility regulator to engage with us at this early stage. We don't want to wait until we have something worked up, make legislation for it, and then engage the utility regulator. We need to engage them in co-design at the stage when we're working things up to ensure that it's the lowest cost, that it's going to protect consumers, and that it's easy and simple to implement.
And those other policy issues that are being worked up, are they going to require legislation, and will legislation covering those policies, will they come within the terms of this mandate?
Yes, they will require legislation. Some of them will require primary legislation, and we are engaging with DSO at the moment on what is the most efficient way of bringing all of that forward. And we do have a timetable of legislation that we're taking forward in this mandate. And if you want more detail of the specifics on that, Paul can give you a list of that.
Yeah,
useful.
So offshore is obviously a key element of sort of delivering 80 by 30, and it's within the Climate Change Act and a duty on the department to deliver. So we're looking to bring forward two bills in this area. So one of them is in and around a support scheme that'll incentivise investment in that area, and the other one is in and around essentially the mechanics of how this is going to work out in the seas. So it's like looking at decommissioning and safety regime in and around offshore. So there are two bills. There's also a bill being brought forward in and around introducing a moratorium on onshore petroleum licensing, and that's quite far down the process. And we're also looking at almost like a wider energy bill where for example, hydrogen is one of the issues that it's important to get the utility regulator to talk to us in, because we know at the moment we have a very modern gas network, and hydrogen can be like a key part in decarbonising the sector. So we're going to need regulations in that. So there's conversations going on with that policy team on what that might look like. And then one of the other things that the bill's allowing us to do is talk to the utility regulator on what we're calling new technologies, so like demand response solutions, aggregated generators. There's potentially pieces of legislation that might be in a larger bill that would be brought forward within the plan is within the current mandate, but a lot of this stuff is how far down the road we get on that, how settled policies are, because you have to remember that we need to provide regulatory certainty. Do you know what I mean? Like we need to be very clear in what we're doing. We don't want to bring forward legislation that's not.
Yes, it has to be specific, it has to be subject to scrutiny, and it has to
Yes.
stand up to, when people look at it, to see does it cause them concerns or
Yes.
address their concerns, that it's very specific in that. It has to be good legislation. So the intention is to, as we work through the policies, each of the policies, is to identify with stakeholders the legislative gaps and identify with the utility regulator where we want to put in regulatory certainty, and talk to the likes of the Consumer Council about where we need to support consumers as we bring this all through. So the intention of the legislation is to address those things once we get through that whole scrutiny process. That's why this particular piece of legislation was needed as a very short piece of interim legislation, just to enable the utility regulator to come and talk to us about these issues, and make sure that we get that legislation that we need.
What's the Department's current position and our plans for domestic customers in relation to try and transition them from home heating oil to a new source?
In terms of domestic customers, we are looking at bringing more renewable electricity onto the electricity grid, strengthening the grid to be able to take that electricity and use that. There are micro generation schemes. We have GB Energy coming on stream. We're talking to DESNES about the support that they can offer, and they're aimed at local and community energy. So the community energy aspect is something that is getting more attention, and we are looking to make sure that local communities have ownership of the way they take things forward. And we already have some pilots running in the area, self-generated pilots, not generated by the department at this stage, but we are involved where they want us to be. And we're looking to actually bring forward some kind of departmental policy on the support we can give them. And we're working with the Consumer Council on a campaign of information and support and advice to be able to actually enable domestic consumers in particular to at least know where their routes are, what it may cost them and all that sort of thing.
Do you see a departmental support scheme for domestic customers to transition from their current fossil fuel usage to a form of renewable energy for either their electricity or their heating cost?
I think it's too early for me to say that, and it's not my specific policy area, but things like the encouraging people to use heat pumps, etc. There's a consultation out on that at the moment, and that's the direction that the policy is going, is to actually examine that and see what is needed to help people transition across. But at this stage, I couldn't say definitively that there will be a scheme or what it would look like.
Anna.
Thank you. Thank you for coming in this morning. It's very, very interesting. As a recent member to this committee, I just wanted to ask a question about the utility regulator. You know, looking at the pack here, I see that their operating costs, 67% of those are in wages for their staff, and just The question really being, do you think they're adequately resourced, and where does that resource come from for the utility regulator to take on extra responsibilities to meet the climate change obligations in the Climate Change Act?
Utility regulator is completely independent and is not accountable to the department, so we don't oversee their budgets in any way. They get a small amount of funding from the Department of Finance, and the majority of their funding comes from licence fees, so comes from consumers. And I know that they do come and talk to you, and they would be happy to talk through that. We don't have oversight of their budget. They're completely independent in that aspect.
And that would come, you'd expect that would come from licences from new energies that they would be regulating, new sources of energy?
Potentially. I mean,
Yes.
as we're developing policy on any new energy sources, the intention would be to ensure that there's a fair and just distribution of the costs, and that takes into account any specific groups of people who may be particularly impacted by any of those policies. So that consumer protection angle is a huge part of all of the policy development that we're doing. It's something we're considering throughout it.
Okay.
Yeah.
Jonathan doesn't have anything. Okay, thank you very much for that. We appreciate that. Obviously, the committee will have some discussions, and then obviously we'll correspond in terms of any views that we have on the bill. But thank you very much for coming along. I appreciate that. Okay, colleagues, if you're content, just going to open up to some discussion. Obviously, I think there's some useful information there. I think that's probably the first time that we've heard that this is an interim bill, and that the Minister has further plans on a number of aspects in relation to legislation around energy, and it probably quell some concerns in relation to this bill not going far enough on some aspects. I did struggle though with the departmental justification for why advice from the UR should only come to the Department for the Economy. Obviously the Department for Agriculture and the Department for Communities have expressed a clear desire that they wish to have that direct access to that information, fuel poverty strategy, and the role that agriculture will play in decarbonisation. I don't know if anyone else has any particular views on the issue, but I'm not sure that the answer as to why the department doesn't believe that other departments should have direct access to the information was fulsome.
Read.
Anyone, anything they want to, might be useful for us just to...
Right.
To write to the utility regulator and seek their opinion on the bill, because the utility regulator weren't happy with the bill when they spoke to the committee a few months ago.
Yes.
Yeah, I got the
It's the
impression
same
today
bill.
that it was yeah. It might be worth asking them directly. Yeah.
And also further to write to the department, just asking for that timetable, because we'd heard about the fracking bill before, knew that, but the offshore support, the wider energy bill, that I didn't think that was happening, so it sounds like it is. Just also, as members will see in correspondence, the department is just doing a call for evidence now around biofuels, so that what it kind of looks like the future might be, would be for Miss Armstrong in her house in Fermanagh, would be you would have a heat pump. You would also have home heating oil, but they would be blended, so there would be biofuels in it. But like in your when you fill in your filling your car with petrol, it says E10. The 10% is biofuel, so that you will have an E10 or an E20 or an E30 for your home heating oil, plus your heat pump. That way, I think you'll be able to retain your radiators, so thus reducing the cost. So, and as the chair intimated, there may well have to be a domestic support scheme to make that all happen, to do that transition. But so we can write to the department in those terms, if the committee's content.
Did you want to say something? No. Members content with that? Okay, we will do that, and then.
So,
And obviously the department will have their own response to the consultation, which hasn't been published yet.
they will respond. So I think the committee's response, we're going to write to the utility regulator and see what they say.
Okay.
And come back in those terms. Also, interestingly, the department indicated that the bill would be introduced before summer recess. I was expecting this in January. I understood this was drafted. So anyway, okay, so summer recess. So there you go.
Okay. We are slightly ahead of schedule, but
Alma's not here, so
Okay.
we want to move on to correspondence.
perfect. So item 9, we'll come back to item 8. colleagues. Item 9 is correspondence, and they begin at page 358 of the meeting pack. Item 2 is at page 360. Members are asked to note a departmental response indicating that the City of Derry Airport and the PSO business case are currently in development. Legal advice has been sought in respect of the transfer of functions relating to aviation policy, moving from DFI to DFE, all of which will be concluded in the new year. Members content to note at this stage?
Chair, again, I don't know if I need to do this in every meeting, but I have already declared that my wife's a member of the board, but happy to do so again.
Okay, content to note. Item 3 then is at page 364. Members are asked to consider a letter outlining concerns around the Westminster Product Regulation and Metrology Bill. The Minister advised that he does not wish to support the bill owing to the conferring of devolved powers to the Westminster Government. Is the committee content to seek a departmental briefing on the devolved implications of the bill?
Yep.
Okay. Item 4 at page 403. Members are asked to note a ministerial response to committee queries on car insurance issues, indicating that the Department of Finance is considering the benefit of legislation in respect of extending the FCA remit to include claim management companies in Northern Ireland, which is a positive development. Are members content to note at this stage?
Yep.
Thank you. We then move to item 5. Members are asked to note a departmental response to committee queries indicating that it maintains a limited fleet of vehicles and one is hybrid. Are members content that we pass this to the Committee for Infrastructure? Thank you. Item 6 of page 409, members are asked to note a departmental call for evidence on using biofuels to transition away from fossil fuels for heating. Dates have not been provided, but it appears that the call of evidence will close in February next year. The department thinking seems to be that biofuels will be blended with home heating oil in order to reduce costs, address fuel poverty and limit greenhouse gas emission. Evidence is sought in respect of the environmental concerns and regulatory framework. Are members content again that we seek a departmental briefing on this, given that the previous witnesses just outside their policy, right?
Yeah.
Okay. Item 7 then, members are asked to note a copy of the Department of Finance response on timelines of departmental responses to the 2024 budget information gathering exercise. Are members content to note? At item 8, members are asked to note a copy of the terms of reference for the Committee of Finance inquiry into financial services. Are members content to note?
Yep.
Thank you. Item 9, members are asked to note a copy of the Open University response to the draft programme for government. Open University is calling for a statutory right to training, leave and lifelong learning, maintenance grants and loans for HE part-time learners, and indicates that 15% of OU learners in Northern Ireland are carers. The OU refers to UK Business Barometer, which identifies skills shortage in Northern Ireland. Is the committee content to write to the OU and seek sight of the data to which they reference? Thank you. Item 10, members are asked to note correspondence from Ulster University over the last 5 years of capital spending by department. This shows that spending in Belfast greatly exceeded any other campus. Members content to note?
Chair, just
Yes.
obviously there is the university's coming in January, isn't that right?
Right,
So if
yes.
the questions we can, yeah. Thanks.
We may be going to them.
Yes, we'll come to that.
Oh, really? Sure, no problem.
Item 475, members are asked to note an invitation to the Belfast Harbour Commission office on the 10th of December. Members content to note? Thank you. Item 477 is an invite to the AGM for the, launch of the annual Human Rights Statement 2024 in December 12th. Members content to note? Thank you. Item 13, members are asked to note information on the events programme for 2025 from UK Finance. Members content to note?
Yep. Agreed, member.
Yep. Item 14 is at page 481. Members are asked to note forward correspondence from a litigant in person to an employment industrial tribunal. This is marked as restricted as includes information of personal nature. Is the committee content to write to the individual indicating that the chairperson / committee's role is based on policy and unfortunately have no role in individual proceedings? Yeah. Okay, we go to the forward work plan then, Peter, item 10.
Okay, members, if you turn to page 486, just to remind members that our first meeting after Christmas will be on the 8th of January, so it's a wee bit earlier than perhaps some other committees, and I hope that's okay with members. They're available then. I will take it that they are. Also, we had some contact from Stephen Kelly and the McGee Expansion Task Force. He can't do the 22nd of January, but he can do the 8th of January, and he assures us that the final report will be available well before then. So would the committee be content to have its meeting on the 8th of January at the McGee campus? We'd have Stephen Kelly and the McGee Expansion Task Force team talking about their final report, and then we'd have the the VC of Ulster University also talking about that and various other issues. So we're keen to do that in Magee on the 8th of January, members.
Sorry.
So you're muted, sorry, Jonathan.
There you go. So
But sure, that would mean we're there on the 8th of January and also there on the 22nd of January.
So my cunning plan, Chairperson, would be that we wouldn't go on the 22nd of January and we would just be here. So that on the 8th we'd have Ulster University, the Magee Expansion Task Force, we'd visit City of Derry Airport that afternoon. That would be our trip to the Foyle. And then on the 22nd we'd be here, and we would have we'd have to drag the Northern and Western Regional Forum, etc. to Stormont. Which is not brilliant, but we have put them off several times. So if members are content to do that, that seems to work.
Yep.
Yeah.
Okay, yep,
Intent.
that is good. Other thing then is that on the 4th of December, the geothermal van with the virtual reality experience, it'll actually be at the apron. So that's the bit at the front steps. They can't bring it into the car park because it's quite big, apparently. So what we'll do is have our meeting. Hopefully members will troop down there after our meeting, take a few pictures of you with your VR helmets on, and it's supposed to be quite informative and all that. So that's all I have, members, if they are content with the forward work programme as amended.
members content?
Yep.
Yep.
Okay, perfect.
Do we have Alma?
No, yeah, she told me she'll be here just before 11, so.
Okay, so we're going to.
Do you want to take your ease?
Yeah, we'll just take a short recess till we wait on our next guest, members.
Thanks, members. So we just take our ease for a second, members. Do you want to go into...
Committee Room 30. Sound. 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 Committee Room 30. signed. Committee Room 30, 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 Sound. 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 Committee Room 30, Sound.
Okay, colleagues, we'll now move to item number 8, which is post-19 send provision in Northern Ireland, and we're delighted at this stage to be joined on the topic of Caleb's Cause by Alma. We're delighted to have you. You're very, very welcome. I'm going to refer members to page 89 of their pack, and also page 96, 192, 208 and 209. Alma White will be known to many members for her amazing campaign and her ongoing dedication to this vital cause. So we as a committee are delighted to have you here, Alma. You're no stranger to Parliament buildings in recent days, and
not anymore.
It's great to see. I'm very happy if you're content to hand over to you.
Thank you. Well, firstly, I just want to thank you for allowing me to come here today to not only share about our campaign, but to give a glimpse into what life is like for many children, young people and their families. It's a journey of pain, sacrifice and guilt, but also a journey with the strongest forces of love, laughter, joy and protection for the ones that we love. That's what drives us. We are forced to arm ourselves with knowledge to try and fight a system that is set up to fail us. We have no pathway, no roadmap, no guidance. We fight for assessments we don't want to face. We fight for school placements that are too few. We fight for services that are too stretched. We fight for transition plans that don't exist. And I'm here with you today, fighting once again for something that should already be in place. Northern Ireland is beyond crisis point for families who have a child or young person with special educational needs. We are in a constant state of waiting, hoping, more waiting, more hoping. Our children and young people always seem to be at the back of the queue. We despair often and are led to push doors open that just lead to new doors with no answers. My son Caleb is 16, and I can honestly say the fight feels endless. I didn't intend to start a campaign, but Caleb's Cause and I was born from sheer desperation for not only my son's future, but the future of thousands of families across Northern Ireland. I never imagined putting my life on screen, or my son, or my family, but I have no choice. That is the theme of today. We have no choice. So I sat with tears as Caleb blew out the 16 candle on his cake, as instead of joy, I felt immense fear. The time of his life I have been pushing to the back of my mind is drawing close. So Caleb's Cause and I was born out of love, hope, and pure determination. As many of you know, our campaign is asking for post-19 special educational needs legislation to be implemented here in Northern Ireland for young people with disabilities. I want to explain some thoughts on why this is needed. Let's talk education and health and care plans. England has these, and as much as we know their system isn't perfect, at least they have something. A model underpinned by the Children and Families Act and the Care Act. Here in Northern Ireland, we have neither of these. We have no choice. A statement of special educational needs ends at 19, and young people become invisible. Their needs grow, and as they enter adulthood, and yet their support is drastically reduced. Education and health and care plans would provide an umbrella for a number of areas such as further education, training, apprenticeships, health and social care, benefits. The list goes on. When my son leaves school at 19, because of developmental delay, he will not be the same maturity as his peers. He will not have sufficient mental capacity to make important decisions and will need a lot of support. I have heard from principals that when young people leave at 19, they may try going to tech, but having a 5-day-a-week nurturing specialist school, they often can't cope. The placement breaks down, and sadly, some end up at home. This often results in parents giving up their work, their jobs, their careers. With no clear pathway and no direct link to school, some don't have social workers, including my own son, whose social worker is currently unallocated due to staffing issues. Although I understand and feel for those staff, it leaves us with nowhere to go when issues arise. And believe me, the transition from child to adult services and all the steps that I need to take as a parent for his future remain a minefield. We have no choice. From bank accounts to trying to figure out how we leave money and who will care for them when we are no longer here, this journey is endless. The worry is endless. The options are few. There are charities that try to fill the gap, but my son doesn't always fit the box of what's offered, and that terrifies me. From the first day we place our babies on a bus at 3, having fought for a special school placement, we must accept that we place full responsibility on for our child's welfare into the hands of strangers. We don't get to stand at the school gate and chat to parents. We face isolation and exhaustion. You spend many days wondering, did they have a good day, and dreading any messages that say otherwise. I will never forget the first day I put Caleb on a big yellow bus. Watching him stare out of the window, looking completely lost, like we had abandoned him. He had no speech. I just saw 2 tears trickle down his cheeks as the bus pulled away. And the guilt we as mum and dad felt was enormous. But you do it because, again, you have no choice. That's what it's like every step of our children's lives. We feel we have very little say, and so we spend a lifetime fighting for the needs of our precious children and young people. So why legislation? I can give you 2 types of answers. Firstly, the emotional one, where I can tell you hand on heart that without legislation, you're saying to parents, give this a go, hopefully it works. We need more. We deserve more. Our young people have waited long enough. Second is the evidence-based answer that historically we can see that without legislation, when changes occur, and believe me, they do occur, for example, priorities and budgets can change under a new government with a new mandate, and the first services to suffer are often the ones not underpinned by legislation. An important point to make is that legislation means continuous support. It forces continuous collaboration between the relevant departments. These departments need to be held to account. Disabilities are lifelong. We are not on par with England and Wales. Why? Us parents want more at this point. We want sustainable services for many years to come, not temporary ones with uncertainty and no routes for a long-term change. We are desperate, and I'm sitting here today, not asking, but pleading with you to do the right thing as an executive. As a committee, I ask you to apply pressure to the Minister. As much as I appreciate his desire to help, we want to know, are our children and young people a priority in the eyes of the law? I also sit here as a messenger for many families and their precious loved ones. You have the opportunity to create a legacy, to change the course of the future of young people with disabilities. No more excuses, no more strategies or consultations. After the report emailed to you prior to today, it clearly suggests such things often just sit on a shelf. Imagine that shelf with all our young people on it. That's what it feels like for us. Right now in Northern Ireland, without laws in place to protect young people with disabilities, they are not seen, They have no voice. It feels that they do not matter. And this is not just an equity issue, it's an equality one. Laws give basic human rights. Please start seeing my son and so many others as human beings who belong and have a place in this world. Legislation is the key to accessing a clear pathway and provides hope and aspiration. I'm sure those of you sitting here with children, grandchildren, and other family members can appreciate that disability does not discriminate. It can happen to anyone at any time. Start telling our young people that they can. If you just spent 10 minutes with any of our young people, you would see that they have the purest hearts. They do not judge. They do not see difference. And yet when the world sees them, that's all the world sees. I know as a committee, when you have panel members brief you, you ask questions. I'm an open book. You can ask me whatever you like. But I would request permission to maybe ask you some questions too at the appropriate time. I'll finish by saying this. Not only cross-departmental support, but also cross-party support is needed. I need you all to be a catalyst in moving this forward now in this mandate. I know it can be done if made a priority. Picture our children lined up, ready to hear whether their future deserves hope and an equitable, fulfilling life, and that pretty much sums up where we as parents are. Once again, left waiting. Thank you for your time. Thanks for listening.
Thank you very much, Alma. It's a very powerful testimony, and you're not just speaking for you and your family, but for countless young people across Northern Ireland. And I know that these sessions seem very formal, so I don't want it to seem like that. It's more of a conversation of what we as a committee can do to support you. Could you maybe just talk us through some of the engagement that you've had with the department to date? Obviously, there's been this dedicated working group set up, and as you rightly say, working groups and all are important, but it's the output and the final outcome from that actually matters. So, just wanted to see maybe how the process is going, because we haven't been updated really from the department on the strategy, on the engagement to date, and where you see it going. Yeah.
So, Minister Murphy has got a task force, I believe, of 3 members of staff that will be employed to the end of this mandate. So what I know is that they are looking at all things SEN, looking at legislation to see whether it does need to be put in Northern Ireland for our young people. So I think they're doing research and speaking to stakeholders, and that's kind of where I am. I'm very, very aware how long it takes to have legislation written. I suppose that's my feeling of desperation at this point, because I'm starting to feel the clock is ticking. So Caleb's life is kind of going alongside this mandate. He will be 19 at the end of it. So I feel like this is, with us being in the plan for government under SEN, I just feel like it's a real opportunity for you as an executive to make this happen, really, because I think we've waited far longer than we hoped as parents. This is not anything new. So my hope is that by March or April, the latest, they'll have a decision. We can stop hanging, waiting, and that then we can move forward and actually see legislation being put together.
And just maybe in terms of then the work at that education at skill level. So I have Cedar Lodge in my constituency who've just got new premises, and I was with the young people just 2 weeks ago, and a lot of their focus is on, now that they've got these new facilities, about their day-to-day needs, so they're able to prepare meals, how they go about their daily tasks, taking them to get public transport for the first time, because that's what that gets to. I'm just wondering, do you think there needs to be a standardisation across special schools or within mainstream for pupils who have additional needs, with a focus on helping them with the tasks that we all around this table take for granted?
Yeah, I mean, special schools do a really good job of teaching life skills, which is great. I think what needs to happen, honestly, is a proper transition, whether you're in mainstream or in special school, because right now my son's almost 17 and I haven't had one. I think they're supposed to start at 14. I'm still waiting. So that transition is really, really key. What I would like to see is a bit more, instead of lumping all our young people into one box, you actually start to look at the individual as a person, look at the profile of that individual, and actually say, what can this child do? What can this young person do? Complex needs are just that, they're complex. You might have, like my son, who on paper, he's bright. Outside of the home, he finds it very hard to speak. So that's very difficult for him to go into maybe work in a cafe. He would need a one-on-one. Often that's not available, and that's not their fault. You know, some things will be available, and I know that charities work very hard to try and accommodate families and really do try and provide. But if you look at the disparity across Northern Ireland, it's just a mess. I think there needs to be a shift in mindset during that transition, that it's not just that young person has complex needs. Okay, so that's a day centre. Yeah. That's not right for my son. He will not be going. What often happens is parents keep their young people at home. I've spoken to many families who, during, you know, once your young person leaves at 19, there's blips along the way, and that's never looked at. It's always get them in there and you assume that's them done. Then the school has no remit anymore, and that young person's left, and the family are scrambling trying to find a way to make it work. It's just, I think the transition is key, but I do think a close partnership with schools, start listening to principals, start listening to the people who are with our young people and with our children, who know them better than anyone else. They should be able to provide you with the necessary information to take a transition plan forward, but it needs to be done. Yeah.
Before I open up to colleagues, you had some questions you wanted to ask us.
I did. Sorry. So I suppose what I'm asking you really is for a bit of help as a committee. You may not be able to answer these today, and I totally understand. I wondered if you could ask the Minister to confirm timeframes regarding the Department of Economy's work to explore the options for legislation and support specifically for young people with special educational needs post-19. Confirm that their team is also looking in detail at options to reform legislation. That was my first question. Is it okay? I've got 3 more. Is that okay?
I'll ask the chairman. That'll give it indulgent digest.
Okay. Also, could the Department for Economy give examples of collaborative working? For example, examples of strategic and joint decision making, so pooling and sharing resources. Another question I have, hopefully you all got to see the report ahead of time. I don't expect that you read it all, but that you will have had your eyes across the report that I sent. So why have actions and recommendations in the report of the inquiry into post-special educational need provision in education, employment and training for those with learning disabilities in Northern Ireland by the Committee for Employment and Learning, why has that not been progressed? That was in the 2011 to 2016 mandate. Why did that just sit and nothing was done? As a committee, I would like to know, do you see the need for legislation? If so, how do you propose to action it and make it a reality in this mandate?
Certainly we will write to the department to confirm timeframes, both in terms of legislation that he believes will be required, but also any changes to legislation that are in place. Alongside that, with the committee's agreement at the end, we will cite examples of where collaborative working and cross-departmental working has delivered. I know there are a number of issues in which the department has previously undertaken this work, so it'll be good to get some examples how that's positively worked and how it hasn't, and how we can learn lessons from that. And we can also look at for an update from the department in relation to those outstanding recommendations from the 2011 report. I have many powers, but I can't speak on behalf of the committee and our individual members in terms of their view as to whether they support legislation, but I imagine in their contributions, their support to date with your pledge behind you and the opportunity to sign it after, I imagine that they will display their support for you, but you certainly have mine. At this stage, I'll open up to questions. So, Diana.
Thank you very much, Alma. Thank you very much and welcome for coming before the committee this morning. I mean, as our chair said, it was a very powerful presentation. I really commend you. Very often in this situation, it takes one very dedicated parent or one particular person to really keep pushing in that household, you know, for what you need for young people. So, I mean, I'm acutely aware of that, and I know in my own constituency, I'm familiar with Willowbridge School and that real problem of transitioning after, you know, from post-school. And I've talked to parents about, you know, that feeling of where do we go now, and that feeling of helplessness. I know in some cases, some retailers have schemes and take young people into that. And I've seen people go in and flourish through that. So I think you have to see the young person as for who they are, as you say, where their strengths are, where their interests are, you know, and certainly the opportunity of progressing to skills for life and work are very important. So it is a really important piece of work to try and, you know, lobby for. So really a question I would have is the needs of young people with special needs, even their therapeutic needs, going on to a formal kind of college scenario, how those can be addressed, the therapeutic, you know, speech therapy, whatever other therapies they may need, and also how you safeguard how do you see safeguarding as an issue going into, and you mentioned how you feel you're just letting go when that young person leaves and entrusting them into a different body completely, how you see that being protected?
Yeah, I think, you know, I'm not saying it's for everybody, but I know for my son, I think about 19, and if I could have a dream, it would be to keep him at his current school till he's 25, because you've already got the specialised staff, you've got people that know him, I know he's safeguarded, you have access to OT, you have access to speech therapy. He's not ready to leave at 19. I'm not saying that that's for every child, because some will. My son doesn't have mental capacity. I don't see that that's going to change. So the inability to make decisions from that, I just think there needs to be more of a nurturing option. I also think, you know, life skills are very important, but it's looking again at further education. So like Caleb loves computers. You know, could he do IT? You get some children, I've worked in a special school, and there was one child and she was nonverbal, but you gave her a microphone and she could sing. And she sang beautifully, you know, and we'd all be like, oh wow. And you just think, why can't she do music? What about the child that maybe isn't as academic but can do cartooning, and, you know, let her do art? You know, there just doesn't seem to be a whole lot of aspiration, but I think, you know, in the environment that they're already in their special school, ideally, it would be for me. And I think for a lot of parents, you just want to hold on to that for a bit longer because you know that they're cared for. And I think that's one way of doing it would be
to extend?
Yes, to extend to 25.
Have you lobbied and put forward that?
I've suggested it, yeah. And I think, you know, if you look at England and Wales have adopted their own system. But, you know, I've said it before, the English model isn't perfect, but it's a model. There needs to be a plan. You know, you can't just say at 19, we'll figure it out as we go along. There has to be a plan. After having a statement in place where parents have got OT on there and speech on there, and you've got transport, you know, that's a whole other issue. There's layers upon layers to this, but there needs to be a proper plan in place.
So, plan and consultation with parents as well.
Absolutely,
yes,
absolutely.
Yeah. Thank you very much, Alma. Thank you.
Thank you. Gary.
Thanks, Chair, and just to concur with colleagues, Alma, thanks for coming along today. You're no stranger to this building. I'm sure you don't particularly at times want to be here, but you're here for the reasons that you've articulated. And I think it is important to say that, you know, if, even in terms of the small steps that have been taken at this stage, you know, it wouldn't have happened without the work of you and your fellow parents, and as well the young people who I think have really in some way almost are shaming us into it and saying, you know what, this isn't good enough, and it is unacceptable. And I think that if we ask why Stormont exists, we really need to look at ourselves and say, well, you know, it's about making a difference and protecting all of our citizens and treating them equally. So, as I say that not proudly, I say that as some self-reflection. I suppose the other point that you made, and I fully support your recommendations, and I think now it's how we move that into actual action. And of course we will sign the pledge today as that commitment. But the legislation that exists in other parts of the United Kingdom and indeed the Republic of Ireland as well, I think there's a piece of work here in terms of, as you say, England is not perfect. But at the same time, there's a piece of work that's already been done. So that whilst we may be behind, there's a strength in the fact that we maybe could learn from some of the mistakes that have been made. So I think that that's something that we need to follow up with the Minister as to what work has been done in terms of lifting pieces of legislation that we can, and we will certainly work on it. So I suppose I was just going to ask you, in terms of the English model, the Welsh model, the Scottish model, is there... In terms of the differences, could you maybe talk us through?
I don't believe there's legislation in Scotland,
right.
Although Scotland kind of offer different things. I know one of the things I'm going through at the minute is looking at, it's kind of off topic a little bit, controllership for my son to try and get access to even getting him a bank account. It's very long-winded. And a parent there was saying, because there's solicitors' fees that come with it. So you could be, in England it's called deputyship. You could pay £3,000 to £4,000 to get a solicitor to help you do this. In Scotland, a parent said to me, we get that funded. And I was like, really? So there's kind of seems to be, like, down south as well, I believe there isn't updated legislation, I don't think, but there seems to be some form of services from what I gather. Education and health and care plans are a big one for me. You know, I think they encompass a lot of areas. I think they would cover a lot for the need. I think what needs to be considered is money is always going to be an issue, but in the long term, actually, I think you might find that it's key. You know, you have to invest in the short term for long-term gains, because I think if we keep going on as we are, we're just going further and further away from it. So
yeah, and I think it's an important piece of work that could be done in terms of that comparison right across, in terms of maybe a paper or whatever from the Assembly, in terms of what the differences are and how that we can obviously build on what has been done. One of the recommendations that you mentioned was around the stakeholder engagement, and I think that is so. Any cases that I deal with in respect of health cases, not individuals, specifically I'm not talking about individuals, but you know, you talk about being person-centred. These are you know, individuals, and how do you see that stakeholder engagement maybe looking? I think it is important that parents are very much involved. They have to be involved because it's these are individual needs that have to be met.
Yeah, again, I think, you know, if I was to make suggestions, sometimes consultations go out online, and I think what you have to remember is parents are exhausted. They don't always see them. You have parents that maybe have special needs themselves that can't fill out forms. So that approach to bridging the gap of communicating with parents needs to change for me. I think one aspect would be, again, to go back to special schools and actually work alongside principals to maybe have more information evenings, because they are the ones that parents go to with the questions, you know, annual reviews and things like that. So it would be really key if young people in their care, if they're made aware of what the options are, and then they could filter down and actually let parents know, because often that's who, you know, we're kind of in contact with the most. I think that's really, really key. One of the things during the transition stage I've thought about for Caleb, I would like to see, before our young people turn 19 and actually leave, mental capacity assessments done. I think that's key, because not every young person's going to need one, but it will give you a profile of the young person leaving at 19. If a young person doesn't have mental capacity, they're not independent, they need more support, and it gives you a profile and a plan that you know that young person can't do this, or okay, it'll narrow it down a bit to say they need more, or maybe they stay on in school, or, you know. But at the minute, that's not really, as far as I know, I don't think that's on the radar. I also think, you know, bridging the gap of once they do leave at 19, helping parents. I've said it in every meeting I've been in, there is no clear pathway. We haven't got a clue from one day to the next. From the age of 3 when they get on the bus to the age of 19, you're constantly finding more and more going, didn't know that. And do you know who actually, the ones that find out, it's parents talking to each other, that's how we help each other. We don't get help in other areas always. It's through experience and sharing that experience. There's just no clear direction as to what's to come, and especially that major transition from child to adult is key. You really need the support. Even as parents, it's terrifying, especially when you have a son who doesn't have mental capacity and they're so vulnerable. So
thank you, Elma, and
sorry,
thanks for the work that you're doing. I know a lot of parents certainly have been in contact with me as well, and they very much see you as a voice for them, and not just for Kayla, but obviously for all those other families.
Absolutely.
So it is vitally important that as a parent that you're taking on that role. So thank you for that.
no, thank you.
Thank you. Thanks very much for coming. Your testimony was very powerful. And I mean, I concur with what everybody else has said to this point. And hopefully, I mean, in the time that this assembly has been back, you know, children with special educational needs, I think, has been given a particular focus. And, you know, hopefully as a result of that and the work that you're doing, good work will come from all of that. I mean, you're obviously here talking about a very particular set of circumstances for children moving into adult, and that's, I mean, it's clear from your testimony and from the activity that your campaign has been involved in that we really need to move towards that. So I mean, there's nobody going to disagree with any of your asks this morning. We're fully behind you. Your campaign have, I suppose, had a few victories to this point, and congratulations on that. I mean, you've mentioned the minister has set up a project team. You know, he's bid 9.8 million, I think, to take forward work and transform issues for children with special educational needs, you know, moving forward. So that all of that is positive and to be welcomed. I mean, I was going to ask you, and you've kind of answered it in relation to I think Diana's question, just about how you see any legislation programs, how you see that for Caleb and others like me, because you've clearly identified not everybody's circumstances are different, and one size fit all isn't going to work for everybody. But in terms of Caleb, you know, how do you see his development, and what type of program would you see that would be needed in his circumstances?
I think for Caleb and for many families, I think he doesn't, you know, he has multiple diagnoses. You know, we started off with autism and I thought, okay, we're done. Nope. ADHD, no. Anxiety disorder, no. Selective mutism, you know, the list just goes on. So for Caleb, he needs a lot of support. He needs prompting. When he leaves the home, he finds it very hard to speak. He's quiet enough in the home, but when we actually go out, it's like he completely becomes frozen. So it makes him just safety aspects, you know, crossing the road. Caleb, look where you're going. You know, I don't relax. You know, we're constantly like, you know, watching everything he does. There's, you know, honestly, I don't know what. If I was to look at what's offered now, I would say I don't know where he fits. You know, I think it would be wonderful to think, oh, maybe he could go in and maybe try something with a charity, but he would need one-on-one support. And the problem is, it's not their fault, but what if they can't provide that? You know, what happens too is often the number of young people that are coming through the system now and leaving at 19 is becoming higher and higher each year. If you can't provide for what's there now, how are we going to place them and where are they going to go? So for me, it's very hard to kind of answer exactly where he fits, but I would say he would need a lot of help wherever he went. Like, ideally, I would keep him at school because I think the staff are incredible. I think special schools should be commended. Classroom assistants, teachers, they go the extra mile. They're just incredible people. And for me, that has been a lifeline for us as a family. And for many families, it's respite because you know that your child's safe. So I think if I had a choice, I would keep him there. Yeah. So,
fair enough. Thank you. Thanks very much.
Thank you.
Jonathan?
Thank you, Chair. Can you hear me?
Loud and clear, sir.
Alma, thank you very much for coming to the committee today. When I first met you in your family home, I knew it wouldn't be the last time we had seen you because you're a very determined lady with a hugely passionate ability to articulate your cause. And, you know, it's credit to you because I don't know where you get the time because you're obviously dealing with very, very complex issues in relation to Caleb and also trying to run this campaign, which has really captured the hearts of many people right across the Assembly. So congratulations. I suppose the one thing that I've been struck on is your thoughts around transition. And obviously from that position, you're talking about Caleb's transition post-19 and you're looking at that from a perspective of somebody that knows it's coming down the line. But you've been able to engage with many young people that have already crossed that line. And their parents. And I suppose when I think of transition, I'm trying to think about transition through government responsibility in terms of departmental. What is the experience of those peers that you talk to about how that transition from responsibility from Department of Education through to Department of Economy, through to Department of Health? What's the experience like for them? And do you think that the funding follows? So, for example, you know, those young people that are with the Department of Education through their school years, special educational needs, special schools that do a fantastic job. It's very resource intensive and it needs to be to give them the proper care that they deserve and need. But does that funding follow whenever they go to different parts of the journey?
No. Honestly, if you want a really honest answer, I'll give you one. It's very disjointed between departments. It's not linked in enough for parents. You're sent from pillar to post, to be honest. It's quite, you know, the problem is as well at 19 is that you lose transport, which is, it really has a knock-on effect. So often what happens is, you know, say you're offered 2 days day opportunity somewhere and it was working from 9:30 till 2. Parents have to take their young person there. They have to pick them up. They then have to take them home and take care of them. There's no employer that I know of that would do that. Allow you. Often parents end up giving up their jobs. But the problem is throughout the trusts across Northern Ireland, everything seems to be different in every trust. So one trust does this, one trust does that. You kind of, I feel like we've just slipped through the net a little bit. I haven't seen a social worker in probably 4 years. We now have, we were told recently, you know, you've now got an unallocated social worker. I totally understand the reasons for staffing. I think they want to prioritise looked after children. I completely understand that, the South Eastern Trust. And I actually really, I would be all for that. But the problem is when you hit a wall and you don't know where to go, I need a social worker. I need someone to link in with. So then you start ringing and you're kind of going, okay, the disability nurse doesn't know. You put me through to this team. Oh, well, you're not on the record, you know, and you're just kind of going, right, okay. So you're kind of feeling your way in the dark quite often. But departments just don't communicate well together today, right now. I'm not saying that won't change.
I'm sorry, how would you see post-19 saying legislation dealing with that particular problem?
Well, it would force it to be a collaboration because you have to work together. You don't have a choice. I think also it's not a one-off. you would be forced to collaborate regularly and maybe actually come together and say, let's create things that work. But you have to talk, because it's not going to work unless everybody has their input. Like, just to throw it out there, at the minute in Caleb's life, I started off thinking, okay, so it's education and health, and oh yeah, now it's economy. Oh, hang on, it's communities because we've got benefits, and now it's justice. That's 5 departments as a parent. I'm now looking at 5 departments with no roadmap, 5 departments that don't necessarily link up. So that's kind of where I'm so passionate about legislation, because I would like to think that will cause a link and it will actually put onus on the government to create something that is going to work and make that collaboration happen. So
yeah, no, I appreciate that, and I think it's just such a difficult landscape to navigate for any parent, never mind politician. And I think it's so important that the funding follows, because, you know, we know the huge pressures the Department of Education, the Department of Health are under, but where a young person is passing through government departments at different stages of their life, the funding has to follow with them, because if anything, some of their needs become more complex. And it's just something that I believe that probably collaboration and government legislation is a very difficult thing to achieve, but forcing them to collaborate has to also tie up with appropriate allocation of funding to make sure it happens and happens appropriately. So thank you for your time, and I wish you well with your continued campaign.
Thank you.
Thank you, Jonathan. And what we'll do then, if you're content, is we'll seek the answers to the questions that you provided to us. We're then going to just do one quick item of committee business, which will only take short. Then we'll recess and go out if you're content, and we'll sign your pledge board. Is that okay? Members, I just want to, on behalf of the committee, thank Alma for her ongoing dedication and fearless advocacy on this important matter, and know that although it's been a difficult journey, you will get there. And it'll be thanks to you and your work. So thank you for your time. Members, I'm just going to check, is there any other business before we come back here after our short recess to look at the strategic plan? No. Members are content then. The committee will formally adjourn then until next week. Thank you.
Committee Room 30. Sound. 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 Committee Room 30, 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 sound. Committee Room 30. Sound. Committee Room 30. Sound.